It's time that we do what we were sent here to do. It's time to act on a bill that, although imperfect, should have been adopted a year ago. It's time to pass a comprehensive farm bill. I stand in support of this legislation. I urge my colleagues to join with me. I yield back.
The gentleman from Minnesota reserves. The gentleman from Oklahoma.
Madam Chairman, I yield to the gentleman from Michigan, Mr. Benishek. 1 minute.
The gentleman from Michigan is recognized for 1 minute.
Thank you, Madam Chairman. I rise today in support of H.R. 1947, better known to everyone simply as the Farm Bill. Over the past 3 years, I've been talking to farmers all over northern Michigan. My district is home to a diverse group of farmers. These family-owned operations are a vital and growing part of northern Michigan's economy, and it has been a privilege getting to know them. Earlier this month, I visited with farmers in Leelanau County. I spoke to farmers on the Bardenhagen farm in Suttons Bay, Michigan. Jim Bardenhagen and his family have been working their farm for over a century, so they know a thing or two about agriculture. Their story is like that of a lot of farmers across the 1st District and this whole country. These farmers have been telling me about the need for a strong farm bill, and I believe that's just what we have here. Look, I understand this farm bill is not an easy issue for everyone. I completely understand. I'm a doctor, not a farmer. So I tend to talk and trust to those who understand these complicated issues best, the farmers in my district. For those of you who don't have a lot of farmers, don't worry, you sure eat. And I'll be happy to give you the number of lots of farmers in northern Michigan. They'd be happy to talk to you.
Gentleman's time has expired.
I look forward to a robust debate, and thank you.
Gentleman from Oklahoma reserves. The gentleman from Minnesota is
Madam Chair, I'm pleased to recognize another new member of the committee, the gentlelady from Illinois, Ms. Bustos. 1 minute.
The gentlelady is recognized for 1 minute.
Thank you, Madam Chairman. I rise today to talk about an issue of critical importance to my district in Illinois, and that is passing a 5-year farm bill. As anyone can tell as they drive across my district, from Rockford to the Quad Cities to Peoria and everywhere in between, agriculture is our #1 industry. My district is home to thousands of farmers and millions of acres of some of the best farmland in the world. It is also home to Caterpillar and John Deere, among the best farm implement manufacturers in the world. And the entire western border of my congressional district is met by the Mississippi River, on which barge transportation of agricultural products is absolutely vital to commerce in the region, in the state, and even the world. Whenever I talk with farmers or those employed in the agricultural business, what I hear more than anything else is that they want and they need certainty. Unfortunately, last year, Congress failed to pass a 5-year farm bill and instead resorted to a short-term extension which expires at the end of September.
The gentlelady's time has expired.
Another minute.
The gentlelady is recognized for 1 minute.
Thank you, Mr. Peterson. As a member of the Agriculture Committee, it was an honor to be part of the farm markup last month. Unlike so much else in Washington, the markup was an exercise in bipartisanship. The entire committee was civil and accommodating toward one another. While the bill we passed is not perfect, it contains many worthwhile provisions. Illinois farmers have endured some of the most extreme weather conditions in recent years, including record floods this year and the worst drought in a generation just a year ago. That is why we need to keep in place a strong and stable crop insurance program, so farmers always at the mercy of Mother Nature can continue to provide the food our nation and our world depend on. The bill also contains an amendment that I sponsored that would help aid improvements to river transportation infrastructure, flood prevention, and drought relief, including the aging locks and dam system along the Mississippi and Illinois rivers. The family farmers I talk with back home in Illinois want the security and the stability of a 5-year farm bill. That is how they can plan for future growth and investment and continue to provide the world with a stable food supply. Let's give them this certainty by passing a 5-year farm bill. Thank you,
The
Madam
gentleman
Speaker.
from Minnesota reserves, and the gentleman from Oklahoma is recognized.
Madam Chairman, I yield 2 minutes to the gentleman, the chairman from Washington State, for a colloquy to Doc Casey.
The gentleman is recognized for 2 minutes.
Thank you, Mr. Chairman. As you know, the Central Washington growers that I represent provide a variety of top-quality produce to people across the country and around the world, including the majority of apples, pears, and cherries grown in the United States. There's no question that both consumers and growers want to ensure that we have the safest food supply in the world. However, Mr. Chairman, I have serious concerns with the one-size-fits-all regulations that the Food and Drug Administration has proposed to govern the way that all fruits and vegetables are grown and harvested. I think that we can all agree that lettuce and apples are grown in completely different ways. For one thing, lettuce is grown in the ground and apples in the trees. That's obvious. It only makes sense that these products should be evaluated based on how susceptible they may be to food safety risks and subjected to regulations that reflect both the risk and the way they are grown. I am concerned that the current regulations would subject all growers of fresh produce to the same requirements and restrictions are nearly impossible to meet for tree fruit growers in my district. There has never been a known food safety problem with fresh apples, and yet if implemented, these regulations risk putting our growers out of business and pushing apple production overseas. Would the Chairman agree that the FDA should evaluate the risks of individual agricultural products based on the best available science and consider the growing methods and conditions of these products when developing regulations under the Food Safety Modernization Act for the safe production, harvesting, handling, and packaging of fresh fruit and vegetables? I yield back to the Chairman.
I recognize the gentleman from Washington's concerns about the one-size-fits-all approach of FDA. In fact, this was one among several concerns we raised during the debate in the House when the Food Safety Modernization Act was under consideration. I share his belief that if FDA is going to be given the task of telling farmers how to farm, it should do so after a thorough examination of the risk of different types of fruits and vegetables, and then based on the best available science, consider the growing methods and the conditions of individual commodities when developing regulations. I fear that in its zeal to achieve marginal food safety gains,
the gentleman from Oklahoma would like to yield himself.
Gentleman yields himself 30 seconds.
30 seconds.
I encourage FDA to reevaluate the proposed regulations, including docket number FDA-2011-N-0921-001, and make the necessary revisions to ensure that they meet this purpose.
The gentleman yield.
Yes.
I would like to thank the Chairman for his words and his attention to this issue that's so important to the growers in my Central Washington district. I look forward to continuing to work with him to ensure that the new food safety regulations recognize the diverse way that farms across the nation grow our food and keep them safe for the public. And with that, I yield back the time and thank the Chairman.
From Oklahoma reserves, the gentleman from Minnesota.
Madam Chair, I'm now pleased to recognize another new member of the committee from California, Mr. Vargas, for 1 minute.
The gentleman from California is recognized for 1 minute.
I thank the ranking member for yielding. Madam Speaker, I would like to thank the chairman and the ranking member of the Agriculture Committee for their leadership and their hard work in bringing a farm bill to the floor this year. I rise in support of many of the provisions in the Farm Act, but with grave concerns about the cuts to the Supplemental Nutrition Assistance Program, SNAP. I strongly support the provisions in the Farm Act that expand funding for the Specialty Crop Block Grants, restore funding for the Specialty Crop Research Initiative, and maintain funding for pest and disease control, market access programs, and organic agriculture. While the Farm Act provides for many positive provisions that support a strong agriculture safety net, the $20.5 billion in cuts to the SNAP program is unconscionable. If the Farm Act is enacted, the CBO estimates that nearly 2 million low-income people will lose SNAP benefits, and another 1.8 million people live in households that would experience a benefit cut of $90 per month. We cannot continue to balance the budget on the backs of our poor, our children, our seniors, and our veterans. I wanted to support a farm bill, but I cannot support because of the cuts to SNAP. But I do thank them very much for their hard work. I yield back.
Gentleman from Minnesota reserves, the gentleman from Oklahoma.
Madam Chairman, I yield the gentleman from California, home of amazingly diverse agriculture, Mr. LaMalfa. 1 minute. The
gentleman from California is recognized for 1 minute.
Thank you, Madam Chairman. I rise today in support of H.R. 1947. Is this farm bill perfect? No. Would I like for it to have done more? Yes. Is this still a bill that modernizes and moves farm bill reform forward? Yes. We've made many landmark improvements and modernized many programs within this bill. The Farm Bill provides logical reforms that streamline our federal government and cut spending and protect our farmers, ranchers, and rural communities. We indeed are reducing spending in the Farm Bill by $40 million, including $6 million in sequestration. We're streamlining the conservation programs to the tune of $13.2 billion by repealing direct payments also. We are also saving money in the food stamps area by $20.5 billion. The Farm Bill offers the first reforms and savings to the SNAP law since the Clinton-era welfare reforms in 1996, modernizing SNAP programs while eliminating waste, fraud, and abuse. In the House Ag Committee, I'm proud to say we added further reforms to SNAP by preventing USDA and states from engaging in SNAP recruitment activities and prohibiting USDA from advertising SNAP on TV, radio, and billboards.
Gentleman's time has expired.
This is a farm bill we need to pass to move in the right direction. I urge your vote.
Gentleman's time has expired. The gentleman from Oklahoma reserves. The gentleman from Minnesota is recognized.
Madam Chair, I'm now pleased to yield 3 minutes to the minority whip, gentleman from Maryland, Mr. Hoyer.
The gentleman from Maryland is recognized for 3 minutes.
I thank the gentlelady. Ask unanimous consent.
Without objection.
I thank the gentleman for yielding. I thank him for his work. I thank Mr. Lucas for his work. We struggle in this Congress to try to bring bipartisan legislation to the floor. It's a shame. I've normally voted for the Farm Bill for a reason I don't express here. First of all, the Farm Bill is an important piece of legislation that sets federal policy in a range of areas that deeply affect the lives of farmers, their communities, and consumers. But it also makes a huge difference in the lives of those who rely on food assistance to avoid hunger, especially children. It's a shame that we could not consider the Farm Bill on its merits without undermining its credibility with what we clearly believe are not reforms, not the elimination of waste, fraud, and abuse. It's so simple to say that. I've heard that for all the time I've been here in Congress. Let's just cut out fraud, waste, and abuse. Everybody wants to cut out fraud, waste, and abuse. But cutting out assistance for hungry people is neither fraud nor waste nor abuse. Well, it may be abuse. The Supplemental Nutrition Assistance Program, or SNAP as it's called, protects over 46 million Americans who are at risk of going without sufficient food. Nearly half of those are children. Are there some reforms that are needed? Perhaps, and the Senate has made those reforms in a moderate, considered way. The average monthly benefit per participant last year, according to the USDA, was $133.41. I challenge any member of this House to live on $133.41 for food. $4.45 a day. $4.45 a day. At a time when millions remain out of work, struggling to support themselves and their family as they seek jobs, it would be irresponsible to make the kinds of cuts that are proposed in this bill. No one in the richest country on the face of the earth should go hungry in this country. Yet that's exactly what this bill would do, slashing $20.5 billion from the Supplemental Nutrition Program and putting 2 million Americans, 2 million of our fellow Americans, at risk. Feed the hungry. Clothe the naked. Give shelter to the homeless. That's not a political policy, that's a moral policy. Our faiths teach us that. While we've cut millions in funding in this bill, this Congress has done nothing to advance legislation that will help create jobs or opportunities to help expand our middle class. While it's important that Congress provides certainty to the agricultural community, which I support, this unbalanced bill takes the wrong approach on these cuts to SNAP. 30 additional seconds. 1 minute.
I yield 1 minute to the gentleman.
The gentleman is recognized for an additional minute.
Thank you, Madam Speaker. I'm disappointed. This ought to be a bipartisan bill. Mr. Peterson wants it to be a bipartisan bill, and many of our people, as a matter of fact, the majority of our people support it in committee. I think the chairman wants it to be a bipartisan bill. I understand he has to deal within the framework of his caucus, like every chairman has to do, on either side of the aisle. I understand that. But it is a shame in a bill that ought to be bringing us together for people who provide this country with food and fiber, and indeed provide a lot of the world with food and fiber, that we have put this almost poison pill. I don't know whether it's going to be a poison pill, but almost poison pill in it. I regret that. It's not worthy of our country. It's not worthy of the morals of this nation. But I thank the chairman and I thank the ranking member for their efforts to try to bring us together. Whether they've done so or not, we'll have to see. I yield back the balance of my time.
The gentleman from Minnesota reserves. The gentleman from Oklahoma.
Madam Chairman, I yield to the gentlewoman from South Dakota, Ms. Noem, 1 minute.
The gentlelady from South Dakota is recognized for 1 minute.
I thank the chairman and the ranking member for their leadership on this issue. Madam Speaker, today I rise, I stand. At this point, I'd even leap for joy for a farm bill that's good for agriculture in this country. This bill that we have today isn't a perfect bill, but it is a good bill. It is bipartisan. It saves nearly $40 billion. It reforms the food stamp program and farm programs. It eliminates direct payments. It consolidates conservation programs. It saves money, gives us a safety net, and it's still accountable to taxpayers. As we debate this bill, though, I don't want to lose sight of a big policy discussion. We decided decades ago that it was important for us to have a farm bill because it was important for us to grow our own food in this country. We didn't want to rely on another country to feed us because we recognized that the instant we did that, we would allow that country to control us. That's why good farm policy is important to our national security. That's why when we go to the grocery store, we can count on buying safe food. We can know that there will be affordable food there at affordable prices. A farm bill is the reason that we all enjoy these benefits. We can't take our food supply for granted. I urge my colleagues to pass this bill this week, and with that, Mr. Chairman, I will yield back.
The gentleman from Oklahoma reserves. The gentleman from Minnesota is recognized.
Madam Chair, I reserve.
The gentleman from Minnesota reserves. The gentleman from Oklahoma.
Madam Chairman, I yield the gentleman from the great state of Texas, Mr. Nogelbauer, 1 minute.
The gentleman from Texas is recognized for 1 minute.
I thank the chairman, and I rise in support of H.R. 1947, the Farm Bill. This is a win-win. This is a win for the American people because they're going to continue to get the safest and cheapest food in the world. It's a win for farmers and ranchers all across the country because now they will have a 5-year farm bill that will give them policy to make the important decisions they need to make run their businesses and their farms and ranches. And more importantly, it's good for a win-win for the American people because this brings $40 billion worth of savings at a time when we're running trillion-dollar deficits. Now, there's been a lot of discussion about what this bill does and doesn't do. This bill does bring reforming over 100 different programs. What this bill doesn't do is take one benefit away from a SNAP recipient that's qualified for that. What we find is there's been some gamemanship in this program, and what we think we owe the American people is to make sure that the people that are on these benefits that are very timely for some folks, but make sure that they qualify for it. So those are people that want to say that this takes money away or food away from families is just not true. I urge you to support this reform bill. It's good for the American people.
The gentleman from Oklahoma reserves. The gentleman from Minnesota
Madam Chair, I reserve.
Continues to reserve. Gentleman from Oklahoma.
Madam Chairman, I yield 1 minute to the gentleman from Iowa, Mr. King.
The gentleman from Iowa is recognized for 1 minute.
Thank you, Madam Chair. I thank the gentleman for yielding. And I come to the floor. First, I want to congratulate the bipartisan effort. I've been through another farm bill, I guess, a couple of times, and I've seen it as we've had a Republican chair, a Democrat chair, a Republican chair. I've seen as Ranking Member Peterson worked hard with Republicans 6 years ago. I've seen it as our Chairman Frank Lucas has worked hard with Ranking Member Peterson over the last year and a half. This is a very, very difficult balance to pull together. But here's what we get with this. First of all, the end of direct payments. By the agreement of our producers, whoever recipient of a government check stepped forward and said, I'll give that up because economically we can do that. And at the same time, we get some reform in the SNAP side of this thing that says we're going to start holding some people accountable without taking a single calorie out of the mouths of those that are needy and those that we want to get those benefits. And in the middle of all of that, if we don't pass a bill, we revert back to the 1949 bill, which would be a calamity. And if we don't address the SNAP version of this, then what we end up with, Madam Chair, is a growing food stamp program. So I urge its adoption. I yield back the balance of my time.
Gentleman from Oklahoma is recognized.
Madam Chairman, I yield the gentleman from Montana, Mr. Dane, 1 minute.
The gentleman from Montana is recognized for 1 minute.
From Montana, as I go back to every weekend, is Congress needs to pass a long-term farm bill. 1 in 5 Montana jobs rely on agriculture, and it's past time for passage of a 5-year farm bill that protects and promotes Montana's #1 industry. We need a farm bill that supports our rural communities and gives the ag community the certainty needed to plant the crops that feed our country and ensure a stable food supply. We need a farm bill that gives Montana farmers relief from burdensome regulations and encourages young people to remain active in their family farms. This bill also contains important provisions for our timber community and for the health of our forests. And as we begin fire season, we have already seen the terrible consequences of the lack of active forest management. It's important we give the Forest Service the necessary regulatory relief in order to protect our communities. In light of our nation's escalating debt crisis, Congress must look to save taxpayer money wherever possible. I am pleased that the Ag Committee has made substantive, cost-saving changes to a wide variety of programs in the proposed Farm Bill, including reforms designed to reduce fraud and abuse in the distribution of food stamps. It's important to get the Farm Bill passed through the House, in the conference, and on the President's desk before expiration. It's time to pass the Farm Bill.
The gentleman from Oklahoma reserves. The gentleman from Minnesota continues to reserve.
Reserve.
The gentleman from Oklahoma is recognized.
Madam Chairman, I yield the gentleman from Louisiana, Dr. Bastani, 1 minute.
The gentleman from Louisiana is recognized for 1 minute.
Thank you, Madam Speaker. And I rise to support this bill, and I certainly appreciate the persistent hard work and the leadership of Chairman Lucas and Ranking Member Peterson. And I want to thank both for bringing this very important legislation to the floor for a House vote. In 2012, Louisiana farmers and ranchers produced nearly $11.4 billion in commodities. It's vital in the growing sector of our state's economy, and we need a new farm bill now to provide the kind of certainty going forward for our farmers. Throughout South Louisiana, the agricultural economy is the lifeblood of our rural communities. This is a bipartisan bill containing truly significant reforms with savings of up to $40 billion. Given the immense diversity of American agriculture, it's important to have price loss coverage, which is an important option for our southern farmers, like our rice farmers. This is critical for their future security. Additionally, an extension of the U.S. sugar program ensures a level playing field with other nations who continue to heavily subsidize their sugar industry with unfair trade practices. I urge my colleagues to strongly support this bill, and I yield back.
The gentleman from Oklahoma continues to be recognized.
Madam Chairman, I yield the gentleman from Nebraska, Mr. Smith, 1 minute.
The gentleman from Nebraska is recognized for 1 minute.
Thank you, Madam Speaker. Thank you, Mr. Chairman. I rise today in support of H.R. 1947, the 2013 Farm Bill. Agriculture is an inherently risky venture, but even in tough times, agriculture remains a bright spot in our economy, and we cannot afford to undermine this success. We should not use the notion of ag producers growing more and wasting less as an excuse to chip away at crop insurance. Thanks to crop insurance design, last year's losses, a result of the worst drought in decades, were not completely borne by taxpayers. Further cuts to this program could mean even increased costs to consumers. This Farm Bill also provides disaster assistance to livestock producers impacted by severe drought, continues investment into agriculture research, a crucial component of food safety, and builds upon conservation efforts already undertaken by landowners across America. While this is not a perfect bill, Madam Speaker, we are here to allow the legislative process to work. I'm hopeful we can pass this bill, go to conference with the Senate, and ensure producers have the opportunity they need to continue to feed the world. Thank you. I yield back.
Gentleman's time has expired. The gentleman from Oklahoma has 1 minute remaining, and the gentleman from Minnesota has 5.5 minutes remaining. The gentleman from Minnesota reserves. Gentleman from Oklahoma is recognized.
Madam Chairman, I would note that I'm the last speaker and would conclude, and might even take a moment or two.
The gentleman from Oklahoma reserves.
If the gentleman would yield me an extra minute or two.
And the gentleman from Minnesota.
I will yield back the balance of my time and.
The gentleman yields back.
To.
Does the gentleman wish to give?
Yes, please.
Okay.
The gentleman from Minnesota yields 5.5 minutes to the gentleman from Oklahoma.
Right.
The gentleman is recognized.
Madam Speaker, I recognize myself for whatever time I might consume.
Without objection.
Madam Speaker, we've heard some very good debate this evening. about the merits and the challenges that we face in putting this bipartisan bill together. I'd like to take just a moment to focus on the nutrition title and the spirit and the logic that went into crafting this. The focus of the committee was that the savings should be achieved across all areas of the Farm Bill, and that $40 billion approximately we have saved does achieve savings in the commodity title, the conservation title, as well as the nutrition title. Everybody under the jurisdiction of the Farm Bill contributes to the reforms. Now, in the nutrition title for just a moment, I just want to stress to my colleagues, the committee tried to achieve savings in a way that would not deny an individual who was qualified under present law by income or assets from receiving help. We just simply say in the committee draft that things like automatic food stamps, categorical eligibility, something that's evolved out of the 1996 welfare reform, we just simply say everyone needs to show they qualify, and we'll help you. The LIHEAP program, where states in some cases give as little as $1 to help their citizens pay their home heating costs, that triggers a full month's worth of food stamps. We say in the bill, states, you've got to give $20 to trigger that. The goal of the committee was never to work hardship on anyone. The goal of the committee in a time of $16 trillion national debt, annual trillion-dollar deficits, was to achieve savings across the board. But it requires that the folks who need help come in and demonstrate they qualify. If you don't like the asset level or the income level, that's a different debate. We just simply say, if you need the help, show us you qualify, and we'll help you. That's a $20.5 billion savings according to CBO. Will that be the way it's implemented? I don't know, but we operate by CBO scores, and almost $40 billion in overall savings in all areas of the Farm Bill. I would challenge all my friends, if every other committee and every other jurisdiction would achieve these kinds of savings across the board, we'd be in a different situation with our operating annual deficit. The Ag Committee's done its work, and we've done it in a thoughtful way. Help us over the course of the next few days with this amendment process. Don't by affection offer amendments simply to prevent the process from happening. Don't do things that are intended not to make the bill a better piece of legislation, but to prevent it. Be good legislators. Be thoughtful legislators. Do what's right, whether it's to help the people raise the food or that other part of our society that needs help on a month-to-month basis. Do them all right. I have faith in you. I believe through good debate and good discussion on good amendments, perfections will be made, a consensus will be achieved, we'll move forward. I have faith in you, my colleagues. With that, Madam Chairman, I yield back the balance of the time.
The gentleman yields back. All time for general debate has expired. All of it? No. Pursuant to the rule, the committee rises. Okay, me, I'm done.
Mr. Speaker, the Committee of the Whole House on the State of the Union have under consideration H.R. 1947 directs me to report to the Congress no resolution beyond.
The Chair of the Committee of the Whole House on the State of the Union reports that the committee has had under consideration H.R. 1947 and has come to no resolution thereon. For what purpose does the gentleman from Oklahoma seek recognition?
Madam Speaker, I ask unanimous consent that all members may have 5 legislative days in which to revise and extend their remarks on the bill H.R. 1947.
Without objection.
Thank you, Madam Speaker.
For what purpose does the gentleman from Virginia, Mr. Goodlatte, seek recognition?
Madam Speaker, pursuant to House Resolution 266, I call up H.R. 1797 and ask for its immediate consideration.
The clerk will report the title of the bill.
Union Calendar Number 77, H.R. 1797, a bill to amend Title 18 United States Code to protect pain-capable unborn children in the District of Columbia and for other purposes.
Pursuant to House Resolution 266, in lieu of the amendment in nature of the substitute recommended by the Committee on the Judiciary printed in the bill, an amendment in the nature of a substitute consisting of the text of Rules Committee Print 113-15 is adopted, and the bill as amended is considered read. The gentleman from Virginia, Mr. Goodlatte, and the gentlelady from California, Ms. Lofgren, will each control 30 minutes. The chair recognizes the gentleman from Virginia.
Madam Speaker, I ask unanimous consent that all members may have 5 legislative days within which to revise and extend their remarks and include extraneous materials on H.R. 1797 currently under consideration.
Without objection.
Madam Speaker, I ask unanimous consent that the gentlewoman from Tennessee, Mrs. Blackburn, be permitted to control the balance of my time.
Lady from California is recognized.
Madam Speaker, I reserve the right to object because I'm wondering why a member of the Judiciary Committee is not managing on the part of the majority. We have, and the chairman is here, we recessed our markup so that all members of the Judiciary Committee could be present. It is generally our practice for members of the Committee of Jurisdiction to manage on both sides, and so the inquiry is why are we departing from that practice? I do reserve.
From seek recognition, the gentlelady from...
Only to say that it's the prerogative of the committee to choose the appropriate people to manage time. I notice that the ranking member is not managing on the Democratic side. We choose to ask someone who is not a member of the committee, and that's appropriate under the rules of the House.
The gentlelady from California is recognized.
I will not object. I just thought it was an unusual procedure, but I will withdraw my reservation and proceed.
Does the gentlelady withdraw her reservation?
Yes, I do.
Without objection, so ordered. The gentlelady from Tennessee is recognized.
Thank you, Madam Speaker, and I yield myself such time as I may.
Without objection.
Thank you. I have to tell you, Madam Speaker, so often we come to the floor and we will hear members say, we're doing this for the children or that for the children, and I have to tell you, this is one of those days that we truly can stand and say, yes, indeed. We are taking an action that will enable so many children to enjoy that first guarantee, that guarantee to life. And indeed, that is the reason that we stand here. The Unborn Child Protection Act is based in science. This is an area that has overwhelming public support, and it is indeed an appropriate response to Kermit Gosnell's House of Horrors and the similar stories that we are hearing emanate from across the nation about what is happening in these abortion clinics. What this does is to limit abortion at the 6th month of pregnancy and includes exceptions so that we can send the clearest possible message to the American people that we do not support more Gosnell-like abortions. It does nothing to ban abortion before the 6th month of pregnancy. It does not affect Roe versus Wade, and we know that it is a step that needs to be taken to protect life. You know, scientific evidence tells us that unborn babies can feel touch. As soon as 8 weeks into the pregnancy, they feel pain. At 20 weeks, indeed, some of these marvelous fetal surgeries that are performed, they administer an anesthesia to these unborn babies. And as I said, public opinion polling shows that 60% of all Americans, Madam Speaker, they support limiting abortion during the second trimester and 80% during the third trimester. So we think that it is incumbent upon this body to take the step that we bring before the chamber today and to recognize science, to bring the law in line with the majority of public opinion, and to stand against what has transpired in the Kermit Gosnell-like abortion clinics. Indeed, I think it is so noteworthy that Mr. Gosnell's attorney, Jack McMahon, stated that he thought the law should be back to 16 or 7 weeks. He said the 24 weeks was not a good determiner, and that it would be a far better thing to have that ban at 16 or 7 weeks. We're not pushing back that far. We're at 20 weeks. We think that this is an appropriate step. At this time, I will reserve the balance of my time.
The gentlelady from Tennessee reserves, and the gentlelady from California is recognized.
Madam Speaker, I yield myself 3 minutes.
Without objection, the gentlelady is recognized.
I rise in opposition to this bill. This will be the 10th vote we've had to restrict women's access to health care since Republicans took control of the House in 2011, and there are plenty of other things we should be doing. The bill imposes a nationwide 20-week abortion ban. It's unconstitutional, but it's also dangerous to health and safety of American women. The narrow health exception in the bill only allows for abortions that are necessary to save the life of a pregnant woman. It's short-sighted at best and cruel at worst. Many things can go wrong in pregnancy, and this bill would force a doctor to wait until a woman's condition was life-threatening before performing an abortion. Non-life-threatening conditions couldn't be treated if this bill were law, which could result in permanent health problems for some women, including infertility. Severe or fatal conditions may also arise for the fetus later in pregnancy, and if enacted into law, this bill would require some women to carry a fetus to term, even in the situation where that fetus has been diagnosed with a lethal medical condition, a heartbreaking scenario. The rape and incest exceptions are insulting and excessively narrow. The rape and incest exceptions that were added to the bill after the committee's markup are just incredibly disappointing. They require reporting the crime to law enforcement prior to seeking care. It shows a distrust of women and a lack of understanding of the reality of sexual assaults. Only 35% of women report sexual assaults, and there are many reasons for that that are complex, including fear of reprisal. 78% of rape victims know their offender, shame, wanting to put the incident behind them. Also, this bill is unconstitutional. It's a direct challenge to Roe v. Wade, where the court held that prior to viability, abortions may be banned only if there are meaningful exceptions to protect a woman's life and health. For over 4 decades, these principles have been upheld, and this bill blatantly disregards them. Finally, I want to urge my colleagues to oppose this bill. It's an attack on women's health, on our constitutional freedoms. It seeks to take important medical decisions out of the hands of women, their doctors, and their families, and instead entrust those decisions to Congress. It's a misguided effort. I oppose the bill, and I reserve the balance
The
of my
gentlelady
time.
from California reserves. The gentlelady from Tennessee is recognized.
Thank you, Madam Speaker. At this time, I yield 3 minutes to one of our great pro-life advocates, Ms. Black from Tennessee.
The gentlelady from Tennessee is recognized for 3 minutes.
I thank the gentlelady for yielding. And Madam Speaker, when I first became a nurse over 40 years ago, I took a vow to devote myself to the welfare of those committed to my care. And it is with this spirit of both protecting life and women's health that I'm proud to rise today in support of H.R. 1797, the Pain-Capable Unborn Child Protection Act. Now, this bipartisan legislation would ban late-term abortions after 20 weeks. I want to say that again. It would ban late-term abortions after 20 weeks, with the exception provided for when the life of the mother is endangered. H.R. 1797 is based on undisputed scientific evidence, which tells us that unborn children at 20 weeks and older can feel pain. These are babies. They can feel pain. And that late-term abortions pose severe health risks also for the mother. For example, a woman seeking an abortion at 20 weeks is 35 times more likely to die from an abortion than she was in the first trimester. There are medical reasons for this. At 21 weeks or more, a woman is 91 times more likely to die from an abortion than she was in the first trimester. Despite these undisputed facts about the baby's level of development and a woman's health, there is currently no federal law to protect pain-capable unborn children or their mothers by restricting late-term abortions. Even at a day and age when we are seeing premature babies that are born at 22 weeks that survive. And as a society, we celebrate the birth of babies, whether it's prematurely at 22 weeks or delivered at full term. And we hope and pray for good health of that baby and the mother. Today, with that same spirit in mind, I urge my colleagues to join me in celebrating and protecting life of both the baby and the mother by passing H.R. 1797. I yield back.
The gentlelady from Tennessee reserves. The gentlelady from California is recognized.
Madam Speaker, I would yield 2 minutes to a former member of the Judiciary Committee, Representative Debbie Wasserman Schultz.
The gentlelady from Florida is recognized for 2 minutes.
There we go. Thank you, Madam Speaker. I rise to strongly oppose the Pain-Capable Unborn Child Protection Act. It has been 40 years since Roe v. Wade, and yet women still have to fight for the right to keep decisions about our bodies between us and our doctors. We shouldn't have to worry that our government will try to intercede in our personal health care decisions. This bill is extreme, and it's an unprecedented reach into women's lives, into women's personal lives. This is a clear indication that the well-being of women in this country is not something Republicans care to protect. It is clear that the members who approved this bill, the all-male Republican members on the House Judiciary Committee, are not only disinterested in protecting the well-being of women, but are also disinterested in the professional opinion of the medical community. We have heard a lot of offensive and downright untrue assertions by Republicans throughout the discussion of this bill, including by the previous speaker. These are assertions that are baseless, completely devoid of medical fact or grounding in consensus among doctors. No evidence has been presented. They just throw statistics out without any citation or reference at all. Just because you say it out loud in the House chamber doesn't make it true. The Republican men who brought this bill to the floor, despite the parade of our women colleagues on the House floor today, do not represent the voices of women in America. Every time we let their voices get louder than ours, we are inching back to the truly dark ages, where a world of barriers from physical to legal to financial stood between women and their constitutional rights. We have worked too hard and come too far to let it all slip away now. As a mother, when I think about what kind of world I want my daughters to live in, it's one where their rights are sacred and their value is recognized. And that means having access to comprehensive sex education, affordable contraception, and yes, safe, legal reproductive services. This bill doesn't work toward creating a better world for future generations of women. It erodes their future by undermining their independence and undercutting their health. I urge a no vote on this extreme, unconstitutional piece of legislation into the personal health and well-being of women, and I yield back the balance of my time.
The gentlelady's time has expired. The gentlewoman from California reserves, and the gentlelady from Tennessee is recognized.
And I yield 15 seconds to myself to respond. USA Today Gallup polls 64% of abortions should not be permitted in the second 3 months of pregnancy, 80% in the third 3 months. The polling company on March 3rd, 2013, 63% of women believe that abortion should not be permitted after the point where substantial medical advice evidence shows the baby can feel pain. At this time, I would like to yield 3 minutes to the gentlewoman from Minnesota, Ms. Bachmann.
The gentlelady from Minnesota is recognized for 3 minutes.
Thank you, Madam Speaker. It's a privilege to be able to stand here today and to speak on behalf of the unborn. I have a picture that was taken just yesterday. All of us as parents love to take pictures of our babies. This is a picture that was taken of an unborn baby yesterday. This is the age of a baby, the youngest age at 20 weeks that this bill is referencing. And this is a picture of the mom. We're here because we care about women. We're here because we care about the unborn. That's why I support this wonderful bill that's before our body today. You see, we had a very recent disturbing account of a late-term abortionist. His name was Kermit Gosnell. His actions have made debates like this more important than ever before. Because under the guise of being a medical professional, you see Dr. Gosnell violently ended the life of viable unborn babies. And in turn, he seriously hurt or even killed some of the women who he claimed were his patients. A few days ago, the minority leader, Nancy Pelosi, referred to late-term abortions as sacred ground when voicing opposition to this bill. I found that to be a stunning statement. What could possibly be sacred about late-term abortion? What could possibly be sacred about dismembering this 6-month-old little baby with a pair of scissors, as Kermit Gosnell did? What could possibly be sacred about listening to the whimpers and cries of a baby? Because you see, we know that babies at this age feel pain when a scissor is put into their body as it comes to an end. You see, we are the people who make the laws in our society, and therefore we have the duty to protect the inalienable right to life of every individual, both the mom and the unborn baby. And 8 weeks from conception, an unborn child's heart begins to beat. By 20 weeks, he or she is capable of sensing pain. And babies as young as 21 weeks have survived premature birth. Madam Speaker, as a woman and as a mom of 5 natural-born children and 23 foster children, I am appalled by the savage practice of late-term abortion. There is no such thing as an unwanted child, and that's why this legislation is so important. It not only protects the unborn, it protects the mom against the lethal practices of abortionists like Gosnell, and women deserve better than abortion. Unborn children deserve their inalienable right to life. Pregnancy is wonderful. It can be difficult, too. That's why we need to show patience and compassion toward every woman as they carry a human life. We are indeed treading upon sacred ground, but it's because we're dealing with the sanctity of every human life. And out of respect for this mom and out of respect for this unborn child, I urge my colleagues to vote yes on this common sense piece of legislation. I thank Mrs. Blackburn. I thank Representative Trent Franks of Arizona, and I yield back.
The gentlelady's time has expired. The gentlelady from Tennessee reserves, and the gentlelady from California is recognized.
May I inquire how much time remains?
The gentlelady from California has 25.5 minutes remaining, and the gentlelady from Tennessee has 21.25 minutes remaining.
Before yielding to the ranking member, I'd just like to note the situation of my friend Vicki Wilson, who found out, unfortunately, in the 20th month of her pregnancy, that her much-wanted and desired child had all of her brains formed outside of the cranium and would not survive, and if she carried the fetus to term, likely her uterus would have ruptured. Under this bill, Vicki would have been forced into that heartbreaking situation. I think that's simply wrong. And I yield now 3 minutes to the ranking member of the Judiciary Committee, the gentleman from Michigan, Mr. Conyers.
The gentleman from Michigan is recognized for 3 minutes.
Thank you, Ms. Lofgren. I appreciate this important debate and participating in it. Members of the House, by imposing a nationwide ban on abortions, performed after 20 weeks. H.R. 1797, the so-called Pain-Capable Unborn Child Protection Act, is nothing less than a direct attack on a woman's constitutional right to make decisions about her health. It criminalizes pre-viability abortions with only a narrow exception for the woman's life. It fails to include any exceptions for the woman's health, and it utterly disregards the often difficult personal circumstance women face when confronted with the needs to terminate their pregnancies. The amended version of 1797, made in order by the Rules Committee last night, attempts to address the nationwide outcry in response to comments by the bill's author at the Judiciary Committee's markup that, quote, incidents of rape resulting in pregnancy are very low, end quotation. As amended, the bill now includes only a very limited exception for rape and incest that would only be available if the victim could demonstrate that she has reported the crime to the proper authorities. This reporting mandate isn't even required in the Hyde Amendment, and it ignores the many reasons why rape go unreported, including the fear of the abuser, fear of how the legal system may treat the victim, and shame. In short, the majority has determined that a woman's word is not enough to prove that she has been raped or the victim of incest. This pernicious legislation would also impose criminal penalties on doctors and other medical professionals. But let's consider the facts, beginning with the sponsor's comments that, quote, unquote, incidents of rape resulting in pregnancy are very low, and that there's no need for an exception. On the contrary, rape-induced pregnancy, unfortunately, I'm sad to say, occurs with some frequency. For example, the Rape, Abuse, and Incest National Network reported that during 2004 and 2005, 64,080 women were raped, and of those rapes, 3,204 pregnancies resulted.
Expired. The gentlelady from California.
I reserve my time.
Reserved. The gentlelady from Tennessee is recognized.
At this time, I yield 3 minutes to the gentleman from Virginia, Mr. Goodlatte.
The gentleman from Virginia is recognized for 3 minutes.
I want to thank the gentlewoman from Tennessee and the other pro-life women who are speaking out in this debate today. Since the Supreme Court's controversial decision in Roe v. Wade in 1973, medical knowledge regarding the development of unborn babies and their capacities at various stages of growth has advanced dramatically. Even the New York Times has reported on the latest research on unborn pain, focusing in particular on the research of Dr. Suni Anand, an Oxford-trained neonatal pediatrician who has held appointments at Harvard Medical School and other distinguished institutions. As Dr. Anand has testified, if the fetus is beyond 20 weeks of gestation, I would assume that there will be pain caused to the fetus, and I believe it will be severe and excruciating pain. Congress has the power to acknowledge these developments by prohibiting abortions after the point at which scientific evidence shows the unborn can feel pain, with limited exceptions. H.R. 1797 does just that. It also includes provisions to protect the life of the mother and an additional exception for cases of rape and incest. The terrifying facts uncovered during the course of the trial of late-term abortionist Kermit Gosnell and successive reports of similar atrocities committed across the country remind us how an atmosphere of insensitivity can lead to horrific brutality. The grand jury report in the Gosnell case itself contains references to a neonatal expert who reported that the cutting of the spinal cords of babies intended to be late-term aborted would cause them, and I quote, a tremendous amount of pain. The polling company recently found that 64% of Americans would support a law such as the Pain-Capable Unborn Child Protection Act. Only 30% would oppose it, and supporters include 47% of those who identified themselves as pro-choice in the poll, as well as 63% of women. In the 2007 case of Gonzalez versus Carhart, the Supreme Court made clear that, and I quote, "The government may use its voice and its regulatory authority to show its profound respect for the life within the woman, and that Congress may show such respect for the unborn through specific regulation because it implicates additional ethical and moral concerns that justify a special prohibition." As the New York Times story concluded, throughout history, a presumed insensitivity to pain has been used to exclude some of humanity's privileges and protections. Over time, the charmed circle of those who considered alive to pain and therefore fully human has widened to include members of other religions and races, the poor, the criminal, the mentally ill, and thanks to the work of Suni Anand and others, the very young. The Gosnell trial reminds us that when newborn babies are cut with scissors, they whimper and cry and flinch from pain. And unborn babies, when harmed, also whimper and cry and flinch from pain. Delivered or not, babies are babies, and they can feel pain at least by 20 weeks. It is time to welcome your children who can feel pain into the human family. I urge my colleagues to support this
The
legislation.
gentlelady from Tennessee reserves. The gentlelady from California is recognized.
Madam Chair, before yielding to the ranking member of the Constitution Subcommittee, I would just like to note that we do not need to change the law. Dr. Gosnell is convicted, and he's doing 2 life sentences in prison for murder under current law. I yield to the ranking member of the Constitution Subcommittee, Mr. Nadler, 3 minutes.
The gentleman from New York is recognized.
I thank the gentlelady for yielding. Madam Speaker, we're back again considering cruel and unconstitutional legislation that would curtail women's reproductive rights. This bill contains a nearly total ban on abortions prior to viability, which the Supreme Court says violates women's rights under the Constitution. Just recently, the U.S. Court of Appeals for the Ninth Circuit struck down a nearly identical Arizona statute saying, quote, "Since Roe v. Wade, the Supreme Court case law concerning the constitutional protection accorded women with respect to the decision whether to undergo an abortion has been unalterably clear regarding one basic point. A woman has a constitutional right to choose to terminate her pregnancy before the fetus is viable. A prohibition on the exercise of that right is per se unconstitutional." Close quote. Perhaps most cruelly, this bill fails to provide any exception to protect a woman's health. The exception for a woman's life is so narrowly written and so convoluted that even a physician wanting to comply with the law in good faith would have trouble determining when the condition is sufficiently in extremis that her condition qualifies. So the morally arrogant authors of this bill would tell a woman who faces permanent injury or disability that she must bear that calamity by carrying her pregnancy to term. Recently added language is supposed to take the heat off the recent uproar over the absence of a rape and incest exception in this bill. But the bill would provide an exception for rape or incest only if the victim first reported it to the authorities. In the best of all possible worlds, every assault would be reported and every rapist prosecuted. But we all know that there are many reasons why rapes and incest often don't get reported. The toll our criminal justice system takes on rape victims, the humiliation, the harassment, the psychological trauma. Why force women to be victimized twice? The only reason we have been given by the supporters of this bill is that women lie about having been raped. So the sponsors are telling us not only that women are not competent to make this very personal decision for themselves, and that we here are more competent, we should substitute our judgments for theirs, but they are also, women that is, are also too dishonest to be believed when they say they were raped. This bill would use the trauma of the assault to erect another unnecessary and cruel barrier to a raped woman. Congress should not side with her abuser to force her to carry that abuser's child to term. The incest exception applies only if the victim was a minor when the incest occurred. Why? Do my colleagues believe that this was nice consensual sex? That if a young woman is abused by her father from age 8 and gets her pregnant at age 18, it doesn't count? Or that she asked for it and deserves it? These restrictions are new. The rape and incest exceptions in the previous legislation passed by this House have no such conditions or restrictions. Even the Hyde Amendment, embodied in the Labor Age Appropriations Bill, says, quote, "The limitations established in the preceding section shall not apply to abortion if the pregnancy is the result of an act of rape or incest, unquote. No conditions, no restrictions, no ifs, ands, or buts. Now some members want to redefine rape and incest to satisfy an extremist base that wants to outlaw all abortions, even for victims of rape and incest.
Gentleman's
I hope
time
that we can agree that
has
no woman
expired.
should ever be forced to carry her abuser's child. Reject
The
this cruel
gentleman's
and
time
unconstitutional
has expired.
language.
The gentlelady from
Thank you.
California reserves. The gentlelady from Tennessee is recognized.
Thank you, Madam Speaker. At this time, I yield 2 minutes to one of our bright young attorneys, Ms. Roby of Alabama.
The gentlelady from Alabama is recognized for 2 minutes.
Thank you, Madam Speaker, and I thank the gentlelady for yielding. I rise to support H.R. 1797, the Pain-Capable Unborn Child Protection Act. This bill would at last prohibit dangerous late-term abortions of unborn children at 20 weeks. That's the stage of development which we feel pain. And I say we, Mr. Speaker, for a reason. Many supporters of this bill are taking to Facebook and Twitter using the hashtag #TheyFeelPain to illustrate the brutal reality of late-term abortions. I applaud their efforts and I appreciate the many notes of encouragement I've received from constituents back home in support of this bill. I certainly hope that they will keep those Facebook posts coming to get the word out about what we are doing here today. But I use the phrase "we feel pain" because I'm afraid too often we speak of this issue like it's someone else we're talking about, some other species. Mr. Speaker, we're talking about human beings, babies far long enough in development to feel touch, to respond to touch. We're talking about us. We were all 20 weeks at one time. Every member in this chamber was, and we all reached a particular point of development at which the prayerful hope for life becomes precious potential and viability. These babies right now are in NICUs all over this country. Having been premature, the babies are laying in a protective environment, trying to build stable breath, reaching to hold the fingers of their mommies and daddies. Yet right now, under federal law, other babies at 20 weeks are still at risk for being brutally, mercilessly, and painfully killed. Madam Speaker, this must end, and this must end because we feel pain. I reached out just a few hours ago via Facebook, Madam Speaker, to my constituents to ask for stories about children that were born at or near 20 weeks, and I want to share one. A constituent named Terry writes that her baby was born at 24 weeks, weighing only 2 pounds, 3 ounces. After struggling initially, her child grew strong and healthy, and that was 19 years ago. Her son is now an adult living out west. I ask my colleagues to support
has expired.
And vote yes for H.R. 1797.
The gentlelady from Tennessee reserves, and the gentlelady from California